Welcome to the Ron Greenwald Show. We bring you stories, insights, and expertise from leading professionals on the life-changing journey that is estate planning. This podcast is for everyone. We will guide you through our team approach to the AGE, the Aging Safari, and crafting the legacy you wish to leave to your children and grandchildren. We will empower you with the choices to enhance your life now and ensure that your family is able to come together for generations to come. Together, we will make a positive difference. Let's get started. Today, I am very honored and humbled to have two amazing guests on our show today. I'm going to do an introduction of each individual. We really have the all-star lineup. We have, I think, somebody who's definitely in the Hall of Fame, and I think somebody who's an all-star on the show as well. My first introduction is Judge David Belz, served for 15 years on the Orange County Superior Court following a distinguished 32-year career as a trial attorney. Appointed to the bench in 2009, Judge Belz began handling family law cases where his focus on high-conflict custody and visitation disputes highlighted his concern for the impact on the stress of children. He's a recognized speaker and writer on this subject, reflecting his commitment to child welfare. In 2016, Judge Belz transitioned to probate court, where he managed complex trust and estate cases. Over 9 years, Judge Belz presided over 88 long-cause trust trials, which maybe has some explanation to what that means, some lasting as long as 22 days. Given Judge Belz's vast experience in personal injury, family law, probate, and trust cases, he believes strongly in the power of mediation. Judge Belz, having heard it all, and I'm sure you have, Judge, has mediated hundreds of cases with the empathy, understanding, and background to foster settlements. Now with Judicate West. So thank you for joining us today.
Thank you, Ron.
My gentleman on this other side of Judge Belz, Matthew Owens, is a partner in the business trial practice group of Sheppard Mullin, specializing in trusts, estates, and inheritance disputes. He has extensive experience in probate court, handling complex cases such as trust contents, elder abuse claims, contested conservatorships, and breach of fiduciary duty matters. His clientele includes high net worth individuals, corporate trustees, and professional fiduciaries, and I can say he wrote a letter last week that got us to the end line, so thank you. Matt is a certified specialist in estate planning, trust, and probate law. His leadership roles include serving on the executive committee of the Trust and Estate section of the California Lawyers Association and chairing the San Diego County Bar Association's estate planning, trust, and probate law section. His legal expertise is regularly sought after in speaking engagements and publications on trust and estate litigation. Matt, thanks for joining us today.
Thanks for having me, Ron.
So, Judge, we're going to start with you first. We talked about this, and we really want to get people in the understanding of the mode. They hear the word trust. Go get your trust done. Go do this to protect your family. What is the history that led us to this point today?
Okay, Ron, thank you. When I was assigned to probate with not a lot of probate background as a practitioner, I had to learn right away what a trust was and what probate was all about. Within the probate arena within the courts, we do a lot of different things. We do probate estate matters, we do guardianships, we do conservatorships, we do mental health. But one of the areas that we do a lot of is litigation in matters relating to trusts, okay? So what is a trust? Most people hear the word, but they don't know the trust. And so a friend of mine, I thought this might be kind of fun. A friend of mine has a hobby of collecting old treatises on trusts. And he's got a book that's called Lewin on Trust from 1842. He's got Bisham's Principles of Trust, 1887. Perry on Trust, 1929. And then a word for those of us who are in this arena of probate and trust, Bogart. He's a preeminent authority on trust, Bogart. Mm-hmm. And his first book was in 1935. So I got the benefit. I was at my friend's house. And he said, "I got to show you these books." And I look at these books. And I go, "Whoa, those things are awesome looking, right?" And you open them and barely want to touch them, right? Mm. But
were these law school readings for you, Matt?
Maybe the Bogart one. Yeah,
Bogart for sure.
Yep.
But I didn't know about some of these others. And so we started talking about it. And I looked at one of the books and I found some fascinating history that most people I didn't know about. And that is, what is a trust and where does a trust come from? And most things have some historical record. Well, the idea or concept of the legal construct of a trust goes back to 1279 in England. And as you know, most of our law is based on English common law. And King Edward I at that time was concerned about the Catholic Church's ownership of a lot of lands. And because it was an institution that didn't die like people die, the lands would stay in the ownership of that institution. And he was concerned that they were maintaining ownership and there was no taxes and it didn't go through an inheritance process. So he passed what was called the Statute of Marmaid.
Marmaid, M-A-R-M-A-I-D. And what that was designed, it was designed to limit the ability of the institution to hold lands. And so obviously that created somewhat of some turmoil within the church institution, and people started to come up with an end around to get around the Statute of Marmaid. And so what they did was the people would buy the lands that the churches were on. Okay.
And then they would become the owner of the land, but they would contract for the church to use the land. So we own it, but you use it, okay? And as a result of that, they did more or less, they avoided the ability to just take the lands away. The churches were still able to function, and people owned them in various forms of ownership. And that was the beginning of what we call use. And so in English law, as in American law, we have courts of equity, and then we have courts of law. And this construct, this legal construct, developed and evolved over time. And it was the courts of equity that were the courts that oversaw these new use mechanisms, if you want to call it legal mechanisms, for ownership of land. And over time, that's evolved dramatically to the point where it wasn't until maybe the 1980s when the concept of using a trust, more or less to save taxes and also to avoid probate, okay? The idea was to have these trusts set up for typically families, husband and wife. They were set up so that it would be an easy transition. If one died, then the other would take over as the trustee or trustor of the trust, and then there would be successor trustees. And so that became a really significant estate planning, and that's when the evolution really of estate planning attorneys was born. And now we have enormous amounts of trusts.
So Matt, given that as a backdrop, how would you describe the most common use of the trust in today's society?
Yeah, sure. So, and I should also say it's very cool for me to be presenting here with Judge Belz, because I appeared before Judge Belz many times as a lawyer, and so now this is a fun thing to get to do, to actually come on your podcast.
Oh, well, thank you.
And be with Judge Belz here in a different setting where I don't have to be as nervous and buttoned up about my presentation and a little more.
I didn't make you nervous, did I?
Well, I'll do before so just on a little backdrop for people that are listening. As you listen to this, you have to kind of think of two things. People listening. One of the members of here sitting today worked at Disneyland as a youth, and you have to guess which one of these two, Judge Belz or Matt Owens, worked at Disneyland as a youth, and the other gentleman has the access to the greatest tomatoes in America. So as you're listening to this podcast, I will let you decide who that is. But in the meantime, we're going to get serious with Matt in terms of today's topic of trust in today's society.
Sure. So, Ron, I'll give an overview of sort of the most common type of trust or types of trust that we see today. So the most common one that your average family is going to have would be a revocable trust. Sometimes people call it the family trust. Sometimes people call it the living trust. That's basically a living, breathing document that you can change during your lifetime. And what it does is it sets up basically an entity that can hold your assets. And then also when you pass, it's got terms that tell the trustee of that trust how to divide up those assets. So that's the most common one, the revocable trust, the living trust, the family trust. Most people that have those, what's going to be in that trust? It's going to be your house, probably your bank accounts if you've gone through the exercise of properly retitling the bank accounts and putting them in your trust, which that's the formal way to do it, is to go to the bank and actually fill out paperwork and change title. A lot of people skip that step, and then it's a problem, or it can be a problem after the people that created the trust pass away. But that's what you put in there. You put your house, you put your bank accounts. You could put it in a more complex situation. You can put interest in LLCs, interest in other entities, that sort of thing. It's really sort of endless in terms of the opportunities you have for what goes into that trust. A less common trust, but that you see in our trust and estates universe, would be the irrevocable or irrevocable trust, depending on how you pronounce that. I've had some debates on
irrevocable or
irrevocable, irrevocable, revocable, revocable. So however you pronounce that, let's just say irrevocable trust. Those are the ones that you set up and then you can't change, or at least you can't change unless you go through pretty extreme measures to make a change to it. For example, going to court and asking a probate judge for permission to modify or reform an irrevocable trust. But for the most part, for purposes of our discussion today, an irrevocable trust is one that once you create it, it's sort of frozen in time. Those terms aren't going to change. And a lot of people use irrevocable trusts for estate tax planning. And there's a whole alphabet soup of different types of irrevocable trusts for different estate tax planning objectives that people might want to try to achieve. But those are the two most common, is just the revocable being your most common, and then the less common is the irrevocable or irrevocable.
Judge, I want to just back to you a little bit on the history, because I find it fascinating. When you read the stories of the founding fathers, they didn't have trust, or did they have trust set up? Or
well, keep in mind, all of this kind of developed as a way of holding property, but not necessarily holding it in the traditional way. A trust is not really a contract. It's more or less a relationship where the property is held in this entity. I like to use it this way. We have community property laws in California. That means that all of the assets in a marriage are part of this community trust.
I know that.
You know that. We all know that. We all learn that. And so it's somewhat in the same way. It's this creation of this, more or less, this entity that is there that holds assets. Most importantly is, who is it that's overseeing and managing those assets? That's one of the most critical things we have to talk about in the podcast, and what that means to those who are doing that. And so we typically call the person who set it up. My wife and I have a trust, okay? We are both settlors, okay? That's the term they use, settlors. We established this trust by putting this document together, okay? But we're also considered trustors, and that means that we have a duty and a responsibility to those assets as trustors. And that means the probate code all of a sudden becomes a part of our reality world, not necessarily directly, but indirectly it's there in the background. And then all of the duties that are part of the code become the responsibilities of me and my wife towards the trust and towards one another. So it's an interesting kind of a creation. And going back to the the statute of marmaids, the idea that this property is in this entity and somebody's managing it, but it's not typically what we would understand a contract to be.
Yeah, and if I could, Ron, just on these terms, because your listeners might hear different terms describing basically the same role. So I agree 100%. What we refer to as the person who creates the trust is a settlor. The tax folks out there, for whatever reason, like to call them grantors, or sometimes trustor instead of settlor. I think it's because they're looking at the Internal Revenue Code, and it uses that language, whereas in the California Probate Code, it's settlor. So I say settlor, but some of your listeners might be thinking, well, what about a trustor, grantor, whatever? Isn't that also the person that creates the trust? Those are kind of the same label, but in this sort of relationship mix, there's a vastly different role, which is the trustee, that is the one that is actually the one that has fiduciary duties, which we can talk about. It's actually the one that's in control of the assets, investment decisions, distribution decisions, making sure the tax returns get filed, that sort of thing. So just wanted to mention that because people might think, well, I've heard of a grantor. Is that the same thing as a settlor? And typically.
And while we're on this, just for purposes of clarity and understanding this, because it can become confusing if you're not used to it. Trust me, when I went to my first overview class, when I was asked to go to probate, I'm sitting there and some of these terms are like bouncing off my head because I didn't have this background. But that's exactly right. Matt's right. Grantor, settlor, they're the ones that set it up, okay? When it's set up, me and my wife set up, we're settlors, we could be called grantlors, we can be called trustors. At the same time, we're also trustees.
Mm-hmm.
So
yeah,
you can be
very important that people understand that.
Yeah, you can be a grantor settlor that set it up, but once it's set up, now this entity has been created with these assets, and now you have a responsibility as the trustee. What's the trustee? They're the ones that are supposed to be overseeing the management and taking care of those assets and preserving those assets or doing whatever needs to be done with those assets. So you can be a trustor and a trustee at the same time, but when my wife and I pass, we are no longer there. And so whoever we've assigned in our trust to take over for us when we pass, okay, they would be the trustee. And that's all. They're not a grant, they're just the trustee.
So, Matt, people go, well, I have a will. Is that not enough? Help us understand that situation. Now, we are in California. I know every state's different, but let's use California.
Sure, that's a great question because a lot of clients come to me and say, well, what about the will? Or the will says this, or the will says that. People who operate in this universe know that because of the way modern estate planning works, and I'll explain that, the will is actually not that important because 9 times out of 10, what the will does is it's what we refer to as a pour-over will, and it's going to take all of the assets that would pass through a probate estate and dump those assets into the trust. And then you say, okay, well, what are the trust terms? That's what I really care about. That's where the action is.
Matt is a litigating attorney, so he's looking for issues within that document that people may have conflict with.
Right, but just briefly, the difference between a will and a trust in terms of the asset mix, what is governed by which of those two. Trust assets are governed by the trust terms. You know, your house is titled in the name of the trust, your bank account's titled in the name of the trust. Those are going to be governed by the trust terms just automatically right away. Assets that are outside of the trust, that would be, let's say, in the decedent's individual name, there's a bank account that didn't get funded into the trust and can't otherwise be picked up under a small estate affidavit, which maybe we won't go into that.
That's a weed.
Yeah, let's leave that alone. But let's say there's assets in the decedent's individual name that have to go through a probate. Those are your non-trust assets that would be governed by the will, so their disposition would be governed by the will, but probably the will, if it's a pour-over will, is just going to say, okay, now we've marshaled that asset through a probate estate, through the court system, and at the end of that long process, we're just going to dump that asset into the trust. Now we're back to the trust and saying, okay, what are the trust terms? So the will matters, and you're supposed to lodge the will within 30 days of death, which a lot of people miss, and sometimes you do need a probate, so you have to get the will admitted to probate. So it matters in certain instances, but it's not the most important component of the estate plan, post-death administration from an estate planning standpoint.
So then, Judge, I come back to you. When you've been sitting up there on the bench, the family's in turmoil, the brothers, their siblings are the rivalries at this point. The teddy bear, mom's teddy bear, did not get into the trust, obviously. How do you adjudicate that?
Well, again, let me just make one more comment because I think this is important for people to understand a little bit more about what we're talking about. Oftentimes when Matt and his firm will set up a trust with a will that pour-overs, oftentimes the bank account, like the checking account, oftentimes that will be set up in a joint tenancy. What's a joint tenancy? It's a form of ownership whereby when two people are on that account and they own that account together, when one of them dies, it automatically goes to the other. Keeping in mind also that one of the reasons why the idea of trust for estate planning developed rapidly in the 80s is people started to have an accumulation of assets. And that gave rise to needs to plan, okay? And so the trust was a way to plan because you could avoid probate. That's one of the reasons why we have trusts, okay?
Let's get into that a little bit. Define avoiding probate. Why?
Well, this is an interesting topic. For one, unfortunately, like right now, the courts are really under. One of the reasons I left the bench is because I'd done everything I thought I could, and I wanted to go out. I really am passionate about resolving cases because I saw the devastation of litigation and how much it would cost and how destructive it was to families. So it's really, we're going to talk more about this, but it's really important to understand that this whole concept is to simplify the process. But depending on the assets, it may not be simple. And we'll talk a little bit more about that. If in the case of my brother and I, my mom and dad had nothing when they came to California. And they just worked hard and built an estate, not a big estate, but they had a house. And my dad was Bank of America for 38 years. He had stocks, right? Well, when they passed, it was really simple for us. Mm-hmm. You take the stocks and you split them, and you take the house and you sell it, right? It was really simple. But if you now have assets that are more complicated, apartment buildings, limited partnerships, corporations, things of that, now you got a little bit more complicated situation in terms of the planning of how to do that. And that's one of the advantages that Matt's firm, Sheppard Mullin, has, and that is they have litigators and planners. And so how you structure this thing is really important because somebody has to decide how that teddy bear and where that teddy bear, because that teddy bear could become one of the most difficult, contentious points that could cause grief to the family. And if there's one thing that I'm adamant about, because I was blessed with a loving family, is I don't want kids to fight over mom and dad's money. But it happens often, right? Unfortunately. And so that's one of the reasons why we're having the discussion. What can we do to avoid that? Because I can tell you how many times I've sat on these cases, these trials, these long trials. And by the way, long cause means I'm the bench judge for 4 or more days. Mm-hmm. I'm not refereeing a jury. I'm not overseeing a jury. I'm the jury, right? That's a job.
You're the judge and jury.
I'm judge and jury. So I got to assimilate every single thing, take the notes, and it's a heavy load assignment. But I can't tell you how many times I've looked at this and look. Just recently I had a case where I go, these were really loving parents. They had 5 kids, and they're gone. And all they wanted to do was to distribute their assets amongst their kids, and now the kids are in World War III over mom and dad's money.
So I have to on the teddy bear thing, just because I have one right now. I just have to tell you.
A teddy bear story?
You have a teddy bear?
It's a stuffed animal. Well, I wish I had a teddy bear. That might be calming in my personal life. But no, there's a teddy bear that's being disputed in a trust litigation matter that I have. I represent one of the beneficiaries, and we had to do this complicated Excel spreadsheet that says, okay, here are all the items, the tangible personal property items, and everyone can say, I want this, I want that, whatever. They've got their column, and they tag which one they want. Obviously won't do client names or give too many details because I don't want to reveal confidences, but I'll tell you, my client's childhood stuffed animal is on the list because it was in mom and dad's house when they passed. My client didn't even put it on her thing because she's like, it's a stuffed animal, whatever, not a big deal. Somebody else, like a cousin, was like, yes, I want my cousin's childhood stuffed animal so we can fight about that. I mean, it's just insane.
So that actually became an arguing point?
Well, it raised a lot of eyebrows as to why you want your cousin's childhood stuffed animal. But this stuff comes up. And
you may want to open it up and see what's inside of that stuffed animal.
That's right. So anyway, that stuff comes up. Another comment too, just to let people know, we're talking about trusts, we're talking about wills. Important to have an estate plan if you have an asset mix where that makes sense. But also picking up on something Judge Belz said, if you've got a bank account that's joint tenancy that with a surviving owner that can inherit just as what we call a non-probate transfer at death. You got a brokerage account that, let's say, has a designated beneficiary that as soon as you die, if you're the owner, the designated beneficiaries, meaning the people that are listed on the form for that account, are just going to inherit it as a non-probate transfer. And let's say you've got a house and you've got a revocable transfer on death deed recorded on the house, which we now have in California as of the last 4 or 5 years roughly, that says where that house goes immediately upon your death. all of a sudden, if that's like your asset mix, which is a lot of people out there, you don't really need an estate plan. So that can be some very
really good point.
It can be some low cost.
Let's kind of summarize that again, because I think that's very important.
Well, I'm just thinking you're possibly one of your average listeners that has a house, a bank account, and an investment portfolio, brokerage account. There are ways to dispose of those assets upon death without ever having a trust, without ever having a will. I still think it's better to have a trust and a will as sort of a backup to capture things that maybe don't pass as non-probate transfers, but there are ways to pass all of those assets without complex estate planning. The house, if you have a specific type of deed that's recorded on that house, it's called a revocable transfer on death deed. It can say, as soon as I die, title passes to this designated person. Okay, so now your house is done, it's resolved. And then for your brokerage account, most of them allow you to have a beneficiary designation form that just says, as a contract with the financial institution, as soon as I, the owner, die, that account's just going to go to that beneficiary. And then my checking account, same thing, you could have a designated beneficiary, but a lot of them are like joint accounts that pass to somebody else. Those are ways to just avoid probate, avoid a trust.
How would that situation work? Incapacity happens. Would that work? Would that scenario work, an incapacity?
Sure, because incapacity wouldn't be a triggering event that would change ownership. So those beneficial interests could still pass the same way I just described. But what you're touching on is a very important point, which is you might need an estate planning just for having agents or fiduciaries step in for you upon incapacity to manage those assets before you die. Because you might lose capacity 5-10 years before you pass, and then there's that interim time period where my scenario of passing those assets at death doesn't really help you in terms of managing them while you're incapacitated.
Yeah, this is a really good conversation because there's so much involved here, and I have to share this with you. I remember when you're reassigned, so here's a civil litigator, and he gets appointed as a judge, and the next thing I know, I'm in family court, which, by the way, I was there for 5 years, and it was the most meaningful 5 years of my professional career.
Why was that?
Because of the kids and because what I could do to try to heal these family conflicts. It was something meaningful to me. I loved it. I didn't really want to leave, but they knew my trial background, and probate was expanding, and they came to me and said, "We want you over here."
And Schwarzenegger called you. Oh, that was
that was our presiding judge, and so I got reassigned to probate, not really knowing probate, right? But I started to love probate because of the complexity of it. But here's what's interesting: this is why it's important to have a good estate planning attorney. It wasn't too long when I was asked by the judges, because I think they had this in mind. Well, Judge Belz has got all this trial background. Maybe he can do our long cause trials because we don't want to do them, right? And so Judge Belz, being Mikey, okay, I'll do it. And I was more than willing to do it. It was a blessing because I started doing these long trust trials, and man, was I learning. But I have to share this so that when you first get assigned to a new assignment, we have this 1 week, 5-day course where you go up to San Francisco and you sit with other judges that have a new assignment. And I remember sitting in that class, this was in January of 2016, right after I got appointed. And there was a judge, his name was Brad DeMeo, and he was a judge, and he was teaching this class. His dad and he were practitioners. They were estate planners. And I remember sitting there listening to Judge DeMeo say, my dad, we've talked about this. He said he doesn't want to trust. He just wants it to be all in probate. And I raised my head, go, what's that all about? And he says, it's way simpler. You don't have to deal with all the complexity of a trust. Now, I have to say this, though. Trusts are very valuable and very meaningful, but I have to tell you, in the almost 9 years, 8.5 years I was in probate, doing a lot of trust trials, long cause trust trials, 88 of them, right? I never had one single long cause probate trial.
Which means what?
Because the problem with trust, and this is why we're having this conversation, is people need to understand what they're doing and how it's going to work. And they also need to understand with their family members what they want to do and how it needs to work. It can be very, very valuable, especially with larger estates. It can be invaluable in larger estates. But there's complications to it that sometimes can result in problems. But the bottom line is, and we'll talk more about this, but there's more to it than just that.
So we are going to actually have 2 episodes today. And so I want everybody to come back and listen to episode 2 when it is released on the different social media platforms, because I really want to get into where the conflicts arise. We're going to get into, Matt, you're in front of Judge Belz and you have a case, and kind of have that discussion back and forth of there was co-trustees, again, we can call it, there were mom and dad appointed their children as co-trustees or tri-trustees, if there's quad trustees, if there's ever been such a thing. Or somebody came in and became a caregiver for mom and dad, and that one of the siblings now wants more money from the estate, or whatever the conflicts arise that you've seen on the courts. That really, if we can help people, empower people when they go and see their planning attorney to ask the questions, where do you see problems arising down the road? That's what I would like to get us all into in the second episode of this podcast. So that's, Matt, I just want to, in terms of when because you see it on the back end so many times, is that now there's conflict, and what are people not asking up front of their estate planning attorney or their attorney up front? I mean, is there one overriding question or questions that they should be asking before we move on?
Well, I'm coming at this from quite a jaded perspective, right? Because 100% of the trusts that I touch, I'm touching because something went awry. But one thing that people, it might not be what they're not asking, it's just, are these clients telling the estate planning lawyers everything they need to tell them in order for the estate planning lawyer to do a good job? What are the family dynamics? Have I communicated to the beneficiaries my decision-making process such that it's not like a total shock to them when they find out what the plan is, what the structure is under the trust? So I think a lot of times it's just arming the estate planning attorney with as much information as you can as the client about, what your goals are and why those are your goals. And a lot of times there's a lack of communication between the husband, wife on the one hand and the kids on the other hand. Maybe there's a blended marriage situation. There's kids from a prior relationship, and so things kind of people have suspicions about why things ended up a certain way. So there could be oftentimes more communication that happens while mom and dad are still alive that could go a long way.
I mean, is that the one thing you probably hear most of? Mom and dad never told me any of this?
Yeah, and then you're just reading the 4 corners of the trust document without much explanation as to why mom and dad decided to severely reduce the share of one child as compared with the others. And you might be able to speculate, well, there was a falling out, or, well, the one kid was financially well off. You see that sometimes. But if no conversation was had during lifetime, and if the trust document itself doesn't really explain the decision, questions start swirling and suspicions start swirling.
So I assume you both heard, well, my brother wouldn't let me have shotgun in the car growing up, and now I'm going after him. Is that a common thread? Is that?
It can be. For sure, if the children of the settlors, the mother and the father, if they develop problems in their relationships, and those relationships aren't self-giving, and they don't trust one another, then that's a formula for some problems later on. And that's one of the things that I think most people need to think about and they need to anticipate, because it would not be a very good idea, but people do this all the time, and that's one of the reasons why we're here. It would not be a good idea to make them, those two that don't really get along or trust one another, co-trustees.
So that's where I'm going to leave episode 1. So stay tuned for episode 2. Judge David Belz, thank you so much. Stick around. Matthew Owens, stick around, and we'll come right back.
Thanks, Ron.
Thank you.
Thank you for tuning in to the Ron Greenwald Show. We really appreciate your participation. This topic is very important, so I encourage you to please subscribe and share on all the socials, and have a great day.